Welcome to our channel, Brilliant Bankers. Today we are going to have a video on the Limited Liability Partnership Act. In this video, we will explore the definition, features, characteristics, and various aspects related to the Limited Liability Partnership. We will discuss the role of designated partners, their liabilities as partners, incorporation and the registration process, as well as the cessation of partnership in an LLP. Join us to gain a comprehensive understanding of this important legal framework that enables businesses to thrive. So, to start with, limited liability partnership. First of all, what is the definition of a LLP? LLP Act or LLP is a legal framework that governs the establishment and the operation of an LLP in India. It provides a separate legal entity, perpetual succession, combining both the benefits of a company and a partnership firm. So, as said in the definition, a company as a legal entity and a perpetual succession also, where in case if there is any crime or criminal cases against a company, the civil cases or civil suits can be filed against a company. What is the case of a partnership? The company has a restriction of its members. What's the case of a partnership? Two-person can be partner, wherein he can start his own business. So LLP, you can have the easy going of a partnership and take all the rules and regulations from the company. So this is an LLP, Limited Liability Partnership. So how was it promulgated? The Lok Sabha passed the Limited Liability Partnership Bill on the 13th of December 2008, which got the assent of the President on 7th January 2009 and further was christened Limited Liability Partnership Act 2009. Now, coming to a question, what is LLP? A Limited Liability Partnership is a formal partnership between two or at least two persons, wherein each business partner is provided with limited liability, which means they aren't fully liable for anything. They are only liable to the core of what amount they have invested in their business. So they aren't fully responsible for all the business debts or liabilities. It is the LLP that is responsible because it is having a separate legal entity. Partners in an LLP are liable for the negligent acts of the other partner who is there in the LLP. But that's a case opposite in partnership firm. If one partner commits a crime, the other partner is also having a problem. He is also involved in it automatically. Hence, we can say that LLP means LLP is a body corporate and has a legal entity separate from that of its partners. What are the features of a LLP? LLP is a body corporate with separate legal entity. It has perpetual succession, and any change in the partners will not affect the existence, the rights, or the liabilities of the LLP. Coming to the characteristics, there should be a minimum of two members in an LLP, and if at any time it is reduced and the partner and the only partner who is available, he knows it for more than a period of 6 months that he is the only partner, he will be solely responsible for any liabilities or loss that's happening in the LLP. Now coming to few definitions, we will go for the definitions of body corporate, partner, and designated partner, because these are words that will be used a lot of times in the act. Coming to the word body corporate, it means a company as defined in section 3 of the Companies Act 2013. Sorry, it's mentioned section 2. It was as per section 2 of Companies Act 1956. Now it's section 3 of the Companies Act 2013 and includes a limited liability partnership registered under this act, or a limited liability partnership that is incorporated outside India or a company that is incorporated outside India but does not include a sole proprietorship or a cooperative society registered under any law for the time being in force, or any other central government may notify by specification on the behalf of it. So, who is a partner? As per section 5 of this act, the LLP Act, any individual or body corporate may be a partner, provided that the individual shall not be capable of becoming a partner of a LLP in few conditions. If he is not a person of sound mind, if he has been discharged as insolvent, or he has applied for insolvency, in all these cases he can't become a partner of a LLP. Terms of partnership. As per section 6 of the act, every limited liability partnership shall have at least 2 members. It's being repeated again and again because these are the terms. And again the 6 months criteria which was said earlier, it is again the characteristics. Now, who is a designated partner? It is defined in section 7 of the act. Again the same wordings, any 2 designated partners, and one shall be a resident of India. What do you mean by resident of India? A person who has been in India for more than 182 days in the previous financial year or the current assessment year. He is the out of 2, one should be a resident of India. And also, if all the body corporates, if all the partners are body corporates, or in which one or more partners are individuals and body corporates, here it is not compulsory that only individuals can be a partner. 2 companies can come together and bring up an LLP. For example, I am taking the there is no company like that, but from my side, the Tata Motors and Ashok Leyland comes together for making up some material that is commonly used by both of them in their vehicles. They start an LLP. It can also be done for them to procure items cheaply. Just for an example, in which one or more partners are individuals or body corporates, then at least 2 individuals who are partners of such LLPs are to be designated as designated partners, and no partner will become a designated partner unless he has given a consent. Every LLP has to file with the registrar within 30 days of the appointment of the designated individual who will be a designated partner, which is to be registered, and each and every designated partner is to get a DPIN from the central government of India. If the incorporation document specifies who are the document specifies who are designated partners, such persons shall be designated partners on the incorporation, may become or cease to become according to the LLP agreement. He shall not become a designated partner unless he gives a prior consent, as discussed earlier. What are the liabilities of the designated partner? As per section 8, every designated partner is responsible for all acts or matters and things that are required to be done by the limited liability partnership in respect of compliance of the provisions of the act, and are liable to specify to limited liability partnership agreement. He is also liable to all the penalties that are imposed to the LLP, and for any contravention he will be receiving penalties. Any contravention of the laws, he will be receiving penalty. So what about incorporation of an LLP? Incorporation of an LLP, it is as per section 11 of the act, 2 or more persons shall subscribe with their name for the incorporation document. Document is to be filed with the prescribed fees to the registrar, and a statement from the advocate or a chartered accountant or a company secretary or a cost working CWA cost work accountant is to accompany the document. And who are these? They are the person who are going to set up or form an LLP. Rules and regulations for registration. As per section 12, when the requirements imposed by or requirements of section 11 has been completed, the registrar shall within a period of 14 days register the document and certify it by a seal. It shall be conclusive evidence that the LLP is incorporated by the specified name therein, and as per section 13, it says that all LLPs should have their official address or a registered office to which all communications and notices may be addressed. Coming to cessation of an LLP, at what conditions is a LLP being ceased? As per section 24, persons may cease to be a partner of a LLP. In what conditions? With an agreement, or on his death, or on the dissolution of the LLP. If he has also been adjudged as insolvent, or he has applied for insolvency also. On these conditions, he can be ceased to be a partner of LLP. Or a former partner. If in case Mr. A passes away and his son, Mr. B, comes to the LLP saying that his father was a partner or a designated partner, and he wants to be a partner and want to take the place of his father. This is not allowed in an LLP, because once a person passes away, his share is given off. Given off means whatever to his nominee, whatever he was worth, and his nominee or the person, his son, can't take up his place. The rules and regulations for conversion of an firm or a private company or an unlisted public company into a LLP are provided in section 10 of the Act, wherein section 55 to 58 describes how a firm or a private company or an unlisted public company can be converted into a LLP. So here we conclude the class for today. We will be taking a separate class for penalties of different acts, so that we can consolidate all the penalties in a single video, and we don't want people to get confused. Thank you. If you do have any questions, please ask it in the comment box. Please do like, share and subscribe the video to your friends who are in need of classes of this kind, and we would request you to put up the comments any suggestions from your side for any kind of improvement also. Thank you. This is Nishan signing off. Thanks a lot.